Motion for debate. The 75th anniversary of the European Convention on Human Rights. Lord Alton of Liverpool.
My Lords, as we mark the 75th anniversary of the European Convention on Human Rights, I must begin by thanking my noble friends on the crossbenches for selecting the motion and by expressing my gratitude to the many distinguished members of your Lordship's House from all parts of your Lordship's House who are participating in this debate. But my thanks also to the Library and many organisations, from the Law Society to the International Bar Association to Policy Exchange, who have sent briefing material. My Lords, the Danish philosopher and theologian Søren Kierkegaard said that life can only be understood backwards, but it must be lived forwards. Now, following Kierkegaard's advice, I'll begin by looking back and recalling the Convention's genesis and achievements, but then say something about its future. In 2013, I opened another crossbench debate marking the 65th anniversary of the Universal Declaration of Human Rights, and recalling that it grew out of the egregious disregard and contempt for human rights, which had resulted in barbarous acts and which had outraged the consciences of mankind. Eleanor Roosevelt, a key figure in crafting the 1948 Universal Declaration, described it as a Magna Carta for all people. The Universal Declaration helped to inspire the European Convention. Both are foundation stones intended to be for all people and not available for selective enforcement according to culture, tradition or convenience. They should be seen as much a declaration of human dignity as a declaration of human rights. In the aftermath of the two world wars, which had both begun in Europe and which claimed the lives of some 77 million people, and where another war rages today, a formidable array of political leaders showed extraordinary zeal and exemplary commitment in creating architecture to uphold the rule of law, intrinsic to which were international covenants, many focused on human rights. In 1946, those barbarous acts, which had outraged the conscience of the world, prompted Winston Churchill to set out the case for a new international order based on the rule of law and human rights. Outraged consciences led to practical actions. Lawyers like Raphael Lemkin, 49 of whose relatives were murdered in the Holocaust, bequeathed the 1948 Genocide Convention, while Sir Hersch Lauterpacht developed the legal concept of crimes against humanity. At Nuremberg, Lauterpacht helped draft the speech of the British prosecutor, Hartley Shawcross, the Labour Member of Parliament for St Helens, later Baron Shawcross, who in turn collaborated with Sir David Maxwell Fyfe, the Conservative Member of Parliament for Liverpool West Derby, later the first Earl of Kilmuir, in the prosecution of Nazi war crimes after World War II, and he played a significant role too in drafting the European Convention on Human Rights. The agenda had been set in Missouri by Winston Churchill in March 1946, where, flanked by President Truman, he famously remarked that an Iron Curtain had descended across Europe. He insisted that, his words, "We must never cease to proclaim in fearless tones the great principles of freedom and the rights of man." 2 years later, speaking in The Hague, he presided at a grand congress of 800 delegates and said this: "In the centre of our movement stands the idea of a charter of human rights, guarded by freedom and sustained by law." The Congress issued a message to Europeans calling for a charter of human rights and, I quote, "a court of justice with adequate sanctions for the implementation of this charter," leading in 1950 to 15 European nations signing the Convention, with Britain the first to ratify it in 1951. The text was largely crafted by a team of Oxford and Cambridge professors, headed by Maxwell Fyfe. Other British politicians involved in the drafting of the ECHR included Harold Macmillan, Samuel Hoare, and Ernest Bevin. The signatories described their convention as a mechanism for, I quote, "enforcement of certain of the rights stated in the Universal Declaration." Churchill wanted, his words, moral concepts able to win the respect and recognition of mankind, urging lawmakers, let there be justice, mercy and freedom. Churchill envisaged a Strasbourg court before which violations, again quotes, in our own body of nations might be brought to the judgment of the civilised world. In a ringing endorsement, the Daily Telegraph said the convention was the turning point when the free peoples of Europe rejected enslavement in the communist system and defeated all attempts to poison and destroy their democratic traditions from within. The Times described it as a crucial step towards safeguarding fundamental freedoms and promoting a common European heritage of justice and the rule of law. The Convention had created a common legal space for over 700 million citizens, prohibiting, amongst other things, torture or inhuman or degrading treatment or punishment, slavery and forced labour, arbitrary or unlawful detention. Its 14 articles protect basic rights, from the right to life to the right to privacy, conscience and religion, freedom of expression, the right to a fair trial, the right to family life and more. The UK subsequently ratified protocols to the Convention on the abolition of the death penalty in all circumstances and 3 additional rights: the right to free enjoyment of property, the right to education, the right to free and fair elections. Parties to the Convention undertake to secure Convention rights and freedoms to everyone within their jurisdiction, underpinned by the creation of the European Court of Human Rights, which deals with individual and interstate relations. My Lords, during the years following its creation, the Convention commanded widespread cross-party support. Lord Chancellors like Viscount Helsham described it as part of, his words, the armoury of weapons against elective dictatorship. Another member of your Lordship's House, Lord Clerk of Nottingham, said pulling out of the Convention was xenophobic and legal nonsense. And on the Liberal SDP benches, notably Lords Wade, Grimond, Jenkins of Hillhead and Baroness Williams of Crosby were lifelong supporters of the ECHR. Margaret Thatcher declared that the UK was, her words, committed to and supported the principles of human rights in the ECHR. Sir John Major reiterated this commitment, and in 1998 Tony Blair incorporated the rights and liberties enshrined in the Convention in the Human Rights Act. Lord Irvine of Lairg told this House the Act does not create new human rights or take any existing human rights away. It provides better and easier access to rights which already exist. The 1998 Act was simply described as bringing rights home. And beyond our home, the ECHR provides reassurance to everyone living and travelling in the Council of Europe area that we share similar enforceable human rights standards. Now, my Lords, notwithstanding recent calls to leave the ECHR, last November this government said it remained fully committed to the ECHR and to the important role that multilateral organisations like the Council of Europe play in upholding it. The Council of Europe, of course, predates the European Union and has no connection to it. 19 member states of the Council of Europe are not members of the European Union, including the United Kingdom, with Russia expelled because of its illegal invasion of Ukraine. The ECHR and the Council of Europe are inextricably bound together. Leaving the Convention clearly means leaving the Council of Europe. Sir Jonathan Jones KC, a former Treasury Solicitor and Permanent Secretary of the Government Legal Department, says that the ECHR withdrawal would, I quote, involve leaving the Council of Europe, which is responsible for the Convention. A resolution of the Parliamentary Assembly of the Council of Europe states that accession to the Council of Europe must go together with becoming a party to the European Convention on Human Rights, while the European Court of Human Rights insists, today more than ever, the Convention is the cornerstone of the Council of Europe, and any state wishing to become a member of the organisation must sign and ratify it. Now, last month, Theodoros Rousseau-Poulos, the current President of the Council of Europe, of the Parliamentary Assembly, gave a Lord Speaker's lecture. We heard him pay tribute to the commitment and to the high-level contribution of the United Kingdom parliamentary delegation led by the Noble Lord, Lord Tuig. To those who today will demand that we leave the ECHR, and therefore the Council of Europe, I would simply ask them to tell us which rights of the Convention they object to. Do we really want to join Belarus and Russia as the only countries not part of any pan-European body? My Lords, in 2001, Parliament created the Joint Committee on Human Rights, which I have the honour to chair, although today I speak for myself and not the committee. But the committee has a remit to examine matters relating to human rights in the UK, and it's historically functioned as a champion for convention rights. The JCHR pays close attention to the cases before the European Court, whose judges are elected by the Council of Europe's Parliamentary Assembly, and we've noted the role of the Convention and the Court by way of example. For instance, by ending the ban on gay people in the military and homosexual criminalisation in Northern Ireland, in prohibiting the retention for life of DNA samples of innocent people, on indiscriminate phone tapping, on the plight of the Sunday Times when they were prohibited from publishing information about thalidomide, on the protection of vulnerable victims of domestic violence, on the combating of racism and to the degrading punishment of a teenager in the Isle of Man. Among our current JCHR inquiries, we're examining the failure to prosecute UK nationals who took part in the genocide in Iraq, for transnational repression and forced labour in supply chains, and previous inquiries included reform of the Human Rights Act and the right to family life. Last week we held a round table on the mental health bill, where we heard stories of detention and incarceration. And earlier this week, my Lords, I met with Volker Turk, the United Nations High Commissioner on Human Rights, to discuss what we actually mean by human rights and how deeply they are connected to the laws we proclaim, the conventions we have signed, and the traditions of liberty and freedom represented by this place. The European Convention on Human Rights is an essential part of that tradition. Malcolm Bishop KC, writing in the New Law Journal, says, "The Convention is now firmly embedded in the common law, and an impressive corpus of jurisprudence has emerged, which, in my opinion, has made this country a better place." My Lords, I agree. To its detractors, and for the record, in 2024, the Court gave just 2 judgments on the merits of cases involving the United Kingdom. A violation was found in one case, and no violation was found in the other. In a commentary earlier this week, Joshua Rosenberg forensically addressed the caricatures and the misattributions which are often wrongly laid at the door of the ECHR. By population, the UK has the lowest number of applications of all member states, 3 per million people, while for all states combined, it was 47.4 per million. The reason, of course, why there are so few UK cases is that broadly we obey the ECHR. Those who want to reduce UK legal standards, and some even, of course, want to tear up the Human Rights Act, would vandalise our constitutional settlement. This, and leaving the Convention in a fit of pique rather than engaging and reforming it, is not worthy of this country or those who entrusted this extraordinary legacy to us. At the outset of my remarks, I recalled Kierkegaard's thought that life can only be understood backwards, but it must be lived forwards. Institutions and conventions are not set in stone. There's always scope for political debate and greater definition of the respective role of parliaments and judges around controversial issues such as border control, an issue which the JCHR will examine. But to throw away all the games would make no sense and merely play into the hands of dictators and enemies of democracy. We're experiencing war in Europe, along with contempt and disregard for international law and institutions, including despicable attacks on the International Criminal Court. We see the rise of autocracies with global reach, even with reach into the UK through transnational repression by hostile states. Rights and freedoms are under assault from within and from without. And in this context, we are therefore right to recall the spirit which 75 years ago animated remarkable leaders. We're entitled to have pride in the significant British contribution in creating both the Universal Declaration of Human Rights and the European Convention on Human Rights, genuine pride in the development of human rights, international law, and the protection of fundamental rights and freedoms. To defend this legacy, my Lords, we must become far more robust in the public domain, in our schools and in our universities, in setting out the patriotic case for these shared fundamental values. In this 75th anniversary year of the European Convention on Human Rights, we are entitled to look back on what was achieved in the ruins of Europe, out of the ashes of Auschwitz. My lords, we must insist that those concerns remain vitally relevant to this day and that they are crucial to our future. I beg to move.
The question is that this motion be agreed to.